I'm here with Justice Elena Kagan. We're in the West Conference Room, is that right?
I don't know. It's either the West or the East.
I think it's the West.
Okay.
Thank you for agreeing to do this interview. This is July 16th, 2015. And I wanted to ask you, first of all, what are you reading right now? This is the summer break.
My summer break?
Yeah.
It's true, we don't have very many briefs to read right now. What am I reading right now? I just finished a wonderful book called The Warmth of Other Suns. It's a history book. It's about the Great Migration of African Americans from the South all over the United States to the Midwest, to the East Coast, to the West Coast, that occurred starting in World War I and continuing up into the 1960s. And the woman who tells this story decided to tell it through three stories. Three people who come from different parts of the South and then went to different places, Los Angeles and Chicago and New York, and in different decades as well. And she tells the story of the Great Migration really through their stories, but as well through additional, providing historical information. And it's a fabulous book. It's quite a long book.
Is it a scholarly book?
She is a journalist. She's not a professor. But I would suspect that, you learn more about the Great Migration from this work than from any scholarly piece that I know, at least. It's a very personal book, but it's jam-packed with information. And it feels to me as though most of her conclusions and insights about this part of our history are right ones. And it's interesting that she takes this sort of historical phenomenon, trend that occurred over many decades and involved many different kinds of people of different classes, some from rural areas, some from urban areas, going to different places, and shows the variety of it, but also shows how it was all a part of a coherent movement that really changed American life, and both in the South and in the North. So it's a fascinating book.
That's also a subject that history books generally traditional history books have overlooked. That is, I think most Americans of about our age, baby boomers, don't know a lot about black migration in the United States.
I certainly didn't.
Nicholas Lemon once wrote a book on that subject.
He did.
Is he mentioned much in this book?
He's not, and I had read that book quite some time ago. It was about 10 years ago. I think it's called The Promised Land.
That's right.
Yeah, and I had thought that was a very good book too, and I've meant to go back and try to compare the two, but I haven't been quite that ambitious yet. I liked his book very much too. I don't remember whether he also did his book through a couple of personal stories.
I think he did not.
Okay.
But
it's part of what makes this book so moving, is that it's an oral history project essentially, and she managed to do these interviews in the 1990s when the three people who are her main characters are quite elderly, are looking back at their lives, but at the same time are full of sort of character and insight and intelligence. It's really quite wonderful.
That's great. How long would it take you to read a book like that?
Well, I guess, I wasn't working on, I wasn't like reading this straight. I had even started it really at the end of term. I don't know, it took me, I guess, a couple of weeks.
How does your regular reading like that differ from your legal reading? Do you think judges tend to learn the art of skimming to find what's important in a way that you probably would savor every word of that kind of nonfiction that you're talking about?
Well, I don't think I've learned the art of skimming. I really do start at the beginning of a brief and go through to the end and read everything in between. Sometimes I think I should learn the gift of skimming, that maybe every brief is not quite worth that kind of attention. But that's the way I read is actually pretty much the same. Sometimes the writing that I'm reading is not nearly as good.
Is there anything that a brief writer might do that would cause you to stop reading the brief and go to something else?
No, I'll always read the brief through. I think that you owe that much to the parties, even if they're lawyers. have not managed to write a good brief or a worthwhile brief or a brief that in any way gives you insight into a case, I'll always keep hoping that on the next page or on the next page or on the next, I'm going to see something. And I think that you owe it to the parties to keep on trying, if you will, even if you're getting nothing back. But those cases are frustrating. You know, you feel as though the parties are not being well represented, and you're having to do the work that their lawyers ought to be doing. And you don't have as much time as their lawyers should have had to do that work. And sometimes you worry that a potentially good case, you just can't see it as that because of the brief that stands between you and the really meritorious legal arguments on a particular side.
Did law school change the way you read?
Gosh, you know, I'm not sure. Law school seems a long time ago. And, you know, I think legal training generally makes you read more closely, more carefully. You know, certainly when I read novels, I read to enjoy the writing, but I don't have a sense of like constantly you know, having to read every sentence carefully so I understand an argument or so I can distinguish it from some other argument. And I think the law really requires you see, it might be the exact opposite of what you said before, that you skim the legal briefs. I think it might be that I read law more closely and carefully and attentively to just try to figure out how all the parts of an argument relates to each other and how good each of them is. And so I would say I devote more attention to reading when I'm reading law than when I'm reading anything else.
Do you read a cert petition the same way you read a brief on the merits?
No, so you caught me there, and because I would say that I do skim cert petitions. You know, I'm really looking for only one thing, which is this worthy of our attention? I don't have to understand the ins and outs of every argument. I don't have to understand the details of the procedural situation. I'm really only looking for a certain kind of information, which appears in the cert petitions, but is surrounded by a lot of other stuff, which is, you know, more or less irrelevant to what I'm really asking myself.
What do you think is the most important part of a brief?
Well, I guess just the main argument. I mean, you know, the statement of facts and are all well and good, and you like people to do that well. But you know, at least for me, it's when I get to the main argument and you know, try to figure out what's there and how good that argument is.
How important is the issue statement to you?
The actual
question presented.
The question presented. Yeah. The question presented, of course, is what we look at when we decide whether to take cert on a case. But once we've taken a case, the issue is the issue. You look at that first in order to remind yourself why you thought you were going to take this case in the first place and what this case is supposed to accomplish. But I think the way in which, the exact way in which it is worded, you know, sometimes, but not all that often, makes the difference.
Do you have any guidelines for your law clerks on how to write bench memos?
And how to write bench memos. I get a bench memo for each case. They help me think about the case. I usually read them after I read the briefs, so I tell them not to bother going through the facts or you know, or summarizing arguments. What I want them to do for me is just to give me sort of their take on a case. So if they were a judge, how would they decide this case? How would they think about this case? And to write that with the assumption that I've already read the briefs, so I know the facts and I know the basic arguments. They don't have to repeat any of that for me. All I want them to do is to basically say, here's how a case looks to me, here's who I think should win, here's why I think they should win, here are the strong arguments on each side, here are the ones that I think are, you know, very weak, and really use it as a jumping off point for a conversation, which is how I use bench memos. So my bench memos are relatively short. They're not quite as short. I think Justice Scalia has extremely short bench memos. But But there are other justices who have much longer bench memos because they're more summaries of arguments. And I think that that's a waste of time for my clerks, given how I prepare. And really, I'm using them as a jump-off point to have a conversation, not only with the clerk who writes the bench memo, but with all my other clerks as well. We all sit around a table in my office, and all of us have read the bench memo. The other 3 clerks have not read the briefs, so it's, I have 1 clerk and I have read the briefs, and the other 3 clerks have just read the bench memo, but are given sort of enough of a sense of the case from that so that we can then discuss the case. So that's what I think of the bench memo is doing, as kind of serving as the springboard for a discussion and maybe an argument among all my clerks and myself.
When they write that bench memo, are they becoming sort of Justice Kagan surrogates? That is, do they take on your personality? This is what the way I think she will see the case?
No, they're supposed to not to do that.
They're not.
They're supposed to do it the way they would see the case. And I want their real views. I don't want them trying to think about what they think I should think. I want to know what they think, and I can figure out what I think. But I like to figure out what I think with some understanding of how the case looks to several other people, and including to one other person who's really delved deep into it. And I like when I have these conversations with them for them to argue amongst themselves. Sometimes in the beginning of the year, I'll have to really urge them to do that because they think it's kind of impolite to argue with each other in front of the justice. They think that will make each other look bad. And I have to say, no, that's your job, is to come in with your real opinions, and whether they disagree with, whether they or don't agree with what you think I'll think, or whether they don't agree with what you think the bench memo writer has said, to argue it. And I learn a lot from those discussions. I listen to myself. I figure out whether what I'm saying seems to make sense as I say it, and I listen hard to them as well.
You are one of 7 justices who, in your judicial opinions, at the end of your first paragraph or at the end of your introduction, you state the conclusion and the holding of the case.
Oh, that's interesting. Who doesn't? It's Justice Scalia?
That's correct.
And the Chief Justice?
You're exactly right.
Okay.
So, Chief
Why
Justice,
don't they?
Well, have you talked about this with them?
I haven't.
I don't know. They simply pose a question at the end of the first paragraph.
And it's like a mystery.
That's right.
Yeah, and you have to read on in order to discover.
That's right.
And sometimes you discover it early and sometimes you discover it later, but never right at the front.
Well, I will talk to Nino about this because I think I like the style of having the holding at the end.
I kind of think
at the end of the first paragraph.
Tell people what's coming. So this is not a mystery. It's not like follow along with me and you'll learn in chapter 13 what happens. Here's the question. Here's what we're going to say the answer is. Now we're going to tell you why. That's the way I think about it. And sometimes, yes, I guess I do sort of wonder why they don't just say what the answer is up front.
I really
it's like they're having sort of fun with it.
It is interesting, though, that...
I mean, those are great writers, obviously.
Oh, yeah.
I mean, Justice Scalia and the Chief Justice are magnificent writers.
They are, yes.
So you have to think that they're doing it with some degree of consciousness, right? This is not an accident. I think that those 2 people think about everything that they do in terms of writing style. So they must have a reason for it. But I don't know what it is.
Do you remember what Justice Marshall's habit was on that point?
I don't remember. Do you?
I don't. What about Judge Mikva?
I don't remember that either. I guess I would be surprised if both of them didn't just say up front that they were the kinds of guys who, here's what we're going to, here's the question that was raised, here's how we're going to answer it. That strikes me as much as in keeping with their personality.
I agree, and that is the vast majority of good judicial writers around the country. There is a strange habit in appellate courts around the country, I don't know if you're aware of this, where judges will have a non sequitur in the first paragraph. The non sequitur will be something like, this case, it comes to us on expedited appeal from a motion to suppress evidence. We affirm. Now, that's a non sequitur, would you
Right,
agree?
right.
So we affirm, it just makes, but so they're stating a conclusion, but it's,
Right.
So this is a court that affirms expedited appeals on motions to suppress. But it makes no sense.
Yeah, yeah.
Are you aware of that?
I wasn't, no.
But you wouldn't admire that kind of opinion, I assume.
I don't think that that would be good. I mean, the point of stating your conclusion, right, is to be clear about what you're doing up front. To be saying what question you're answering it, how you're answering it, and you know, maybe given even a little bit. Occasionally I do this, sometimes not, depends, about why you're answering it that way. But mostly the rest of the opinion is for the why.